take a constitutional right, wrap it in paperwork, surround it with technical traps, and then pretend that you've respected it. The case is called Woolford versus Lopez, and it came out of Hawaii. After the Supreme Court's Bruin decision said Americans have a constitutional right to carry handguns outside the home for self defense, Hawaii responded with a new kind of restriction. Instead of saying, you can't carry at all, Hawaii said, you can't carry on private property that's open to the public unless the owner gives you express permission. So, in plain English, that means if a licensed concealed carry holder walked into a store, gas station, hotel, coffee shop, restaurant, some other private business open to the public, he could be breaking the law unless the business had specifically authorized firearms. Now, the Supreme Court described that as a serious burden on people trying to exercise their Second Amendment rights in ordinary daily life. Now, understand what the court did not say. The court did not say private property owners have rights. The court did not say that every store owner must allow guns. It's not what it said. A private property owner can still put up a sign, make a policy, and say, no firearms in this property. That's property rights. Unlike what Ketanji Brown Jackson was trying to do, that's property rights. That's up to the property owner, not the state. Okay, that's an owner making a decision about their own business. But what Hawaii tried to do instead was different. Hawaii tried to flip the default rule. Instead of the owner choosing to ban guns, the state tried to make guns banned everywhere unless the owner said affirmatively, yeah, you can bring a gun. That is not the same thing. It is not. That's government using private property as the delivery system for a public carry ban. And that's why that matters far beyond Hawaii. The same game we keep seeing from blue states after major Supreme Court rulings. When they lose directly, they try to win indirectly. They try to sniggle their way around, right? So when the court says you can't ban something, they make it nearly impossible to do. When the court says citizens have a right, they respond with creating rules that make exercising that right burdensome and so confusing that legally dangerous that ordinary people say, screw it. And that's the real story here. The Supreme Court said Hawaii's rule hobbles the right of Americans to carry arms for self-defense as they go about daily life. The majority said the law was unconstitutional because it departed from the ordinary rule that private businesses open to the public are open unless the owner says otherwise. Hawaii wanted the opposite rule for firearms: no carry unless the owner affirmatively says yes. And here's the key point for our audience here. Constitutional rights are not supposed to defend on whether government officials like the culture of your state. The court specifically rejected Hawaii's argument that its unique customs and local views should change the meaning of the Second Amendment. Alito's opinion said the Second Amendment has the same meaning in every part of the United States. That is exactly right. The Bill of Rights is not a regional suggestion box. It's not stronger in Texas and weaker in Hawaii. It's not more real here in Florida and less real in New York. It applies to the entire country. And this is where I would make the episode bigger than about guns alone, okay? Because this case is about the Second Amendment, yes, but it's also about the left's larger strategy towards constitutional liberty. They rarely say we are abolishing our rights. They say we are regulating. They say we are protecting public safety. They say we are respecting local values. They say we are balancing interests. But somehow the balance always seems to land more on the government power side and less on the individual freedoms side. The dissenters saw it differently. Justice Kagan argued that Hawaii's law should have been upheld because she viewed it similar to older laws requiring permission before carrying firearms onto private property. Justice Jackson joined Justice Sotomayor, also argued that the court was mishandling the history and tradition test from Braun. That dissent gives you a fair contrast to explain here. The left will frame this as a private property case, which is really kind of funny, right? They'll say, why shouldn't private property owners have the right to decide whether guns are allowed? But the fact of the matter is, they do. The state doesn't, but the businesses do. Because this isn't a case about forcing private businesses to allow guns. This is about stopping government from using private businesses to erase the right to carry. The Constitution does not require the government to like your rights. It does not require politicians to approve of your rights. It doesn't require progressive states to celebrate your rights, but it does require them to respect your rights. And that's what happened here. Hawaii tried to make the right to carry a permission slip right. Supreme Court said no, no. You don't need a special invitation from the government to exercise a constitutional liberty. The default in America is supposed to be freedom. Restrictions must be justified. Rights do not have to beg for room to exist. And that's why this ruling matters. Because whether we are talking about speech or religious liberty, property rights, parental rights, due process, or the right to keep and bear arms, the principle is the same. The government does not get to regulate a constitutional right into practical extinction and then pretend the rights still exist on paper. My name is Willie Lawson. This has been the Morning Report. Until we see you again, go out there and learn something, love somebody, and for goodness sakes, y'all take care of yourself. We will see you when we see you. Bye-bye now.